Hi, everybody. Welcome to Trial Alchemy. Today, I'm happy to have with me David Munoz as my guest. One of the things that ABOTA has done in the last years, I think it became the official national policy in 2014 or 13, that the new requirement for people to apply to be accepted into ABOTA is 10 jury trials to conclusion. And David's a great example, and you'll find out about this today, of somebody who is started practicing more recently, but he's gotten the more than enough cases to qualify for ABOTA. And we're going to talk about that and his experiences today. So let me tell you a little bit about David Munoz. He practices both in California and in Texas, and he's been practicing. He's been a lawyer since 2010. His law firm is Mission Personal Injury Lawyers, and he does personal injury work and has done that for a number of years. And in the 14 years that he's been practicing, he's obtained a number of great verdicts and settlements, including 2.5 million in a premises liability case, $1 million in hotel negligence case, over $1 million in a rideshare accident case, 1.3 million in a bicycle accident case, and 1.8 million in a negligent security case. So he's been listed in a lot of things like top attorneys. He's listed in super lawyers, and he has been a member of ABOTA for a number of years here. And also, David went to the Jury Spence Trial Lawyers College back in 2013, which a lot of plaintiffs lawyers go to. So without any further ado, David, thanks for joining me today, and I'm glad to have you as a guest.
Thank you very much for having me.
Well, listen, let's talk about this. One of the challenges for younger lawyers these days, when I got into ABOTA, you had to have 20 jury trials to conclusion. It took me about 14 years to get there. So it took a long time even then, but it's even taking longer now. So when you started out in 2010, I don't know if you wanted to go into ABOTA immediately, but how did you go about trying to get the 10 jury trials to conclusion minimum accomplished in a relatively brief time period? What did you do?
That's a great question. And it's one I get asked a lot. And when I first started out, I didn't even start in personal injury. I started in intellectual property. And, when I went to law school, I never thought about myself just being a transactional attorney working at a desk. I went to law school to be a trial lawyer. And I had some political ambitions as well, which I've lost. But besides the point, I still wanted to be a trial lawyer. I still like trial law. And I wanted to find the best way to be able to accomplish that. And so I left intellectual property, and I actually asked my father, hey, would you be interested in starting a firm here with me so we could, have our own practice? And because of my background being in, biology, physiology, personal injury just seemed a great fit because it was a marriage between my background and the law. And I'd done some criminal law, I'd done some family, I've done a lot of different things. When I first opened, they call that door law, where you just take everything that comes through the door. And I just liked personal injury the best. I felt that it was a righteous cause and I enjoyed it. But over the years, I learned that it was pretty hard to get into the courtroom. Sometimes the cases, the client doesn't want to go to trial, and then you'll find that to be the case in for a lot of clients that they're
Right.
hesitant to even go into litigation, let alone trial.
Right.
And then sometimes it can be cost prohibitive. It's going to cost you more to go to trial than the case is actually worth. So I found it a little problematic to want to be a trial lawyer when I'm never getting into trial. And I feel like specifically for a lot of areas of law and personal injury and civil litigation, if you don't know how to try a case, it's like being a bodyguard that doesn't know how to fight. You're going to end up trying to negotiate your way out of the case as opposed to really getting the full value for your client. And so I knew that was important. And that's something that's kind of changed a little bit nowadays, and I'll get into that. But the way I was able to accumulate so many trials was I went to attorneys that I knew were at a point in their career where they're not going to try certain cases, or firms that I know probably just settle cases as opposed to try them. And I just asked them, hey, I'm a trial lawyer. I want to be a trial lawyer. And do you have any cases that you don't feel are worth trying, or perhaps you just want help with, to help spread the costs and the work, and I'll try them for you. And that worked great. The majority of the cases that I tried ended up being other lawyers' cases, and that still happens to this day.
Well, I think it's really important what you said about there are a lot of lawyers. ABOTA lawyers are some of the few who really try cases, but
Right.
there are a lot of lawyers who take a case and they only prepare it to settle. The problem with that is the insurance companies and the defense lawyers know who the settling lawyers are. They're
Exactly.
never going to pay the top dollar. They're never going to pay what is probably a reasonable value. And the only way you're going to get that is if you're somebody who's willing to go to trial and you know how to do it, and you're willing to take the risk of losing, which you always have at trial, but you'll be well prepared. So I think you did absolutely the right thing, and I give you lots of credit for that. And you probably have found lots of lawyers who are willing to take you up on this. So is this a path that you think that other lawyers who want to become trial lawyers and want to be able to qualify for something like ABOTA, it should work for them as well?
Definitely. At least that's my opinion. I think I run across a lot of people who don't see the value in learning how to try cases. But I think that um, if I'm a consumer, if I'm somebody looking for a lawyer, I'm looking for somebody that's going to be competent in their profession.
Right.
Part of that competency is knowing how to try a case. And if you can't do that, can you really consider yourself competent in what you do? And I think that knowing all aspects of the job, trial law is part of it. And so I would be hesitant to consider myself a real lawyer if I didn't know how to do it. And I think that at a certain stage in your life, in your profession, um, the phrase "this case isn't worth trying" shouldn't exist for you. I think that you can talk yourself out of trying any case, but realistically, I mean, if you want to learn how to do this, that phrase shouldn't exist in your mind. And there's plenty of places you can go, plenty of firms you can go to ask for that experience. And look, you get it done in cheaply. I mean, I think the scariest thing would be if your biggest case that you ever had is also going to be your first trial, where you've had no experience whatsoever trying any cases. That just seems crazy to me.
Yeah,
Uh,
that's not the time to be trying $1 million or multi-million-dollar case.
no, and
That's the
then
first time you've gone to trial.
correct, and what you're going to have to do is you're going to have to either refer it out or associate somebody on because you don't have the competency to try it. So, in order to get the experience, why not get it done cheaply, where you're spreading the work and you're spreading the cost with another firm? And yeah, maybe they're not giving you the biggest cases, and maybe you lose, but at least you're losing small, as opposed to losing on bigger cases where you're spending hundreds of thousands of dollars in costs. Um,
Well, you also, if you're going to be a trial lawyer, you have to be willing to lose,
yeah,
because there's no trial lawyer that I know of who really tries cases who's never lost a case, whether they're plaintiff for defense.
right.
And you always have that risk, and you can't be afraid of that. You got to be willing to go in and fight for your client. And, even though the jury might say, nope, we don't agree with you.
Yeah,
So you got
exactly.
to do that. And the one thing I found, I'll tell you an example in my life is when I was trying a lot of plaintiffs med mal cases. I tried this case against a well-known defense lawyer in town, med mal defense lawyer, lost it. You're devastated when you lose a case because you only take it because you think you believe in it and
Right.
should win the case. And so I thought it was horrible and I was in a funk for a while. But what I noticed over a few years is in handling other cases against that same lawyer and their firm, they treated me different. All
Mhm.
of a sudden, it made a big difference in later cases where other clients got fair treatment. And, you got to try some cases, you don't have to try all cases, but they were very different in the way they approached. So the loss was actually a victory in the long run.
Absolutely. There was one year where I had tried 3 cases in a row, and it was around Christmas time, so that was a little tough. But that next year, I didn't have to try any cases.
Yeah.
Uh, so it works out as long as you're willing to do it. And you're right. I mean, it's scary. Uh, and your ego is one thing. You don't want to lose any cases, and that's something you have to get over. But if you're a small firm and you're barely starting out, losing, $10,000, $15,000, it's a big hit. And so that's why I think the plan of going to other firms and asking that they can try cases and you split the cost, you split the work and everything works out great because you're not losing so big.
Well, that's a good point. Now, in terms of the cases that you've tried, and having gone to the Trial Lawyers College that Jerry Spence runs, I actually had an experience back in about 1999 or 2000. They did a 3-day seminar out here in Palomar Mountain, San Diego. First time they'd ever done it away from the ranch. And you got to learn about that. I thought it was very useful, interesting information. Do you use any of the things that you've learned, or do you use lots of the things that you've learned from that experience in your trials? And what things have you found to be most helpful?
I do use a lot of TLC methods. Um, I kind of get things from everywhere. I love Mo Levine, a lot of his stuff.
Yeah,
Um, I get it from everywhere. And the thing that I always tell people is um, use what's going to be genuine and useful to you, because Jerry Spence can do stuff that there's no way I could ever do. I couldn't get away with that. Mo Levine, the same thing. Um, but there's certain things that when I say them, yeah, okay, that sounds okay coming from me. It sounds genuine because I talk that way, or I act that way. There's some arguments that they can say that it won't sound the same coming from me. Um, but I definitely use a lot of stuff. The ball on damages. I mean, Rick Friedman, Nick Rowley.
yeah.
There's so many people that I draw inspiration from that I utilize at least the ideas and then see if I can make them my own, or if I can't use it, I don't use it.
Well,
But
that's a very important point. I think you want to learn from everybody you can and steal any stuff that you think you can use, but you got to make sure it works for you.
right,
And just because some great trial lawyer is telling you something, there's a temptation to say, well, I better try to do that. But if it's not you, it's going to be a disaster.
right. And that's one thing I think I could tell you um changed TLC changed about me. Um, and that's what I think the main point of that program is to make sure that you're you and you're genuine. Because if you're not, the jury's going to see that. The jury
Yeah.
can see when that doesn't seem like he really meant that, or it sounds like he's pulling something. And so you really want to come across as genuine to build credibility. And if you're out there faking it, they're going to know it.
Yeah, they're going to know it. They're going to catch you on that.
Yeah.
So in terms of some of the trials you've done, we talked about this before we went on the recording here, and I know you've had the experience in California. We've got a thing called the expedited jury trial, and you've done some of those. And I tend to think that that could be a useful tool for younger lawyers to learn how to try cases and not have as much expense and make it a shorter experience. What are your thoughts on the benefits of expedited trials?
They're invaluable. especially when you're starting out or you have a lower value case. I mean, I think at the first stage for a lower value case, I think the jurisdictional amount is 12,500 now for small claims.
Yeah.
So that's the most efficient for those value cases. Next level would be the limited jurisdiction, which you get an expedited jury trial. And if you want trial experience, I mean, there it is, done cheaply. You have 8 hours per side to present your case. You can use declarations instead of live testimony for experts, so that saves you money. I mean, there's just so many advantages, and you're going to get the opportunity to do your opening, your closing, examine witnesses. I mean, there's
How
no.
long do you get to pick the jury in an expedited trial?
I think I remember it was 15 minutes per side. Yeah.
And how
But
many
look,
jurors do you use?
it's 8. You
8.
have 8, and you have to waive your ability to appeal, which could be problematic for some people, but for a case at that value where you're really going to spend the money to appeal it, uh, probably not. But there's a possibility. There's instances where that could happen, in which case you just file unlimited.
Well,
But
what do you think about this? I mean, I think the expedited jury trial was kind of thought of as using in auto PI cases that are smaller cases. But it seems to me that you could use that same thing to give younger trial lawyers experience in contract cases and real property cases and just distill it down to the essence and do it fast and get a decision. What are your thoughts on that?
yeah, no, I think it'd be great for any case of that value. And I think you said it right when you said distilling your case down to the essence, because I think that's what you want to do anyway.
Right.
If you're up there, and I've had this experience, and thankfully I was on the other side where I made it short and sweet, and it was in Orange County, and the defense attorney was very long-winded, and the jury doesn't really want to be there listening to you give a speech on civics.
No.
They want you to be short and to the point, and give them the evidence that they need so they can make a decision, and don't waste their time. And
Yeah.
I think again that it's a good training tool for that.
Yeah, well, that's great. So thanks for talking about those things. Let's jump into some other things. And you've tried a number of cases. You're a member of ABOTA, and you've been at ABOTA, and you're actively involved in our San Diego chapter. What's one of your satisfying or most satisfying trial victories or results?
Um, Probably my first civil trial that I did on my own. That another attorney thankfully gave me the opportunity to try, and it wasn't the amount that I got that made it satisfying. It was a very clear case of the defense taking advantage of the fact that my clients were African American.
Mm.
2 of them had recently been released from prison, and their client was Caucasian, and he had just recently returned from Afghanistan. And one of the things that we fought about in motions in limine was whether or not his client could testify in his dress uniform. And the judge thankfully ruled that he couldn't, because this isn't a military tribunal. You're just trying to sway the jury and give yourself more credibility. It seemed a little prejudicial. So thankfully the judge didn't allow him to.
Mm.
But they did everything under the sun to try and discredit these 3 gentlemen who got T-boned. And it's a defense attorney that everybody in town knows, and he fights hard on every case. And that was my first jury trial, is against this gentleman, and I knew I was going to get a lesson in trial law. But I also knew I could deliver a decent closing, and so I pretty much just took it in the stomach and against the ropes the entire trial, until it came to closing, and I just delivered what I thought would be a good closing, and took note and reminded the jury of what was happening. what we saw throughout the trial, and how my clients have been put through that, not just in the accident, but throughout this trial. And
Yeah.
you witnessed that. And thankfully, they did the right thing, and they gave us, the value of what we thought the case was worth. And I think for me, the most important thing was the fact that they found that the defendant was negligent, and they gave anything, because I was just so upset at how they just treated these gentlemen throughout the entire process.
Well, good for you. Thanks for sharing that. So you mastered the rope-a-dope in that first trial,
I don't
as you
I don't want to
were.
say I didn't want to say rope-a-dope, because I don't think the defense attorney is a dope by any means. He's a good lawyer. Um, but
No, you took a lot of hits.
I did take a lot of hits. I mean, gosh, that was a lesson in trial for sure.
So, David, when you're getting prepared for trial and you're in the last stages, whether it's a month or however long you do, what's your routine that you do to really get ready? Because there's a lot of work you got to do. I call it the grind, where you have to just be going over the evidence, going over the depots, going over the exhibits, all that kind of stuff. What's your process?
Um, well, I think first and foremost, it's good to have summaries of everything so you can access it quickly. And then for me, I always prepare every case from the end. So every single case that I get the jury instructions. And I say, okay, if I want to prove this, what evidence do I need? Okay,
Yep,
that means I need to put this in my discovery questions. From this witness, what do I need? So I'll make sure I ask that in deposition.
yep,
And the same thing is true in the trial. Okay, now I know, and after discovery and after deposition, I know I have this and this. How am I going to get this evidence in? What evidence is this witness going to bring in? What evidence is this witness going to bring in? Whatever.
yep.
If I can't get it in through this witness, who else can I get this in? So I just kind of create a plan, and each and every examination, um, it's a plan of how I'm going to get this evidence in. And I prepare my closing before everything else. And I know that sounds contrary to what a lot of people do, but the reason I do that is because I practice, okay, and if everything comes in perfect, what am I going to say? And how do I, and so that way I can show the jury, this is what you have to make this decision, and come with us. And so once I have all of that, it's like my roadmap for everything else. And then my opening is just basically, this is what we anticipate this witness is gonna say. This is what, it's kind of just an introductory of what the case is gonna be. And hopefully, if everything comes in right, I'll be able to recite my closing the way I planned it, with just a few tweaks here and there as things go through trial. But
Well, that's great. And you have to do all those things, like figuring out not only looking at the jury instructions, it's good to look at the special verdict forms for the different kind of case you're going to have, so you know what exact questions they're going to have to answer, and you have to get the evidence so they can give the answer you want.
right,
You have to figure out how you get all that evidence in, whether it's something you can get, maybe you'll get some stipulations, but maybe you're going to have to authenticate, maybe you're going to have to do all the things you got to go through, use business records, whatever you got to do, and try to
right,
get it in. So you got to figure all that out. And then
yeah,
I
and
think your idea of doing the closing early is good, because um, when you've handled a case for a few years, you can get way too deep in the weeds. And when you're trying the case to the jury who's never heard anything about it, you got to be talking to them and making sense for them. It's more like a big picture thing, whether it's your opening, here's what we think is going to come in, or your closing. So I think that's a good approach you're doing.
thanks. Yeah, like I said, it's all about distilling it down to the essence to
Yep.
make it understandable and clear for the jury. And
Yeah.
that's what I try to do. Try not to over try cases or over litigate. Um,
Good.
but on the plaintiff side, you don't want to do that anyway, because, on our side, time is money. And if you're wasting a whole lot of time doing superfluous, law and motion stuff, it's just not gonna, you're not billing.
Right.
So
You're
for
not billing.
yeah, exactly.
Now in your prep time, one thing I want to ask you as a younger lawyer, the last couple of years, we've had the advent of artificial intelligence or AI. And
Mhm.
are you finding that you're using that kind of tool in your trial prep and getting things ready? And what have you found to be useful in that?
Oh gosh, AI is so great. With a caveat, um, you can use IA because I remember I used Chat GPT to help me with the motion, and it came out with this case law that was amazing, was exactly on point. And then we looked up those cases on Westlaw and realized that those cases don't exist. And so thankfully we didn't turn in the motion that way. And
That's good.
I think there's a lawyer that actually got in trouble for that.
Oh, there was about a year ago.
Yeah, yeah. And so thankfully we caught it and we didn't, submit it, but you have to be careful. But it's great uh for getting a general understanding of a lot of law that might be a little intricate that you don't deal with lots of times, or even if it's stuff that you do deal with, but you forget about that little detail.
Right.
It's great. A friend introduced me to a program called Perplexity, which I feel like I use almost every day now.
I think I've heard of it. Isn't that a new search engine or something?
Yeah, it's an AI generated
Yeah.
search engine. And I mean, I ask that so many questions every single day. I don't do my own thinking anymore. It feels like I'm just, why not just ask Perplexity? So that's what I do.
You got to be careful. You're going to become thoughtless.
Right. And that's the fear, I think. I think the doomsday fear is, we're going to have a whole bunch of humans on Earth that just get lazy and don't think for themselves, and there's no
Mhm.
critical thinking.
Well, that will continue to evolve. So it'll be interesting to see how that goes. So in your plaintiff's cases, and you're always on the plaintiff side, and you're typically personal injury, some kind of a tort. And so you're talking about that kind of stuff. So what are the kinds of themes that you've found to be most useful when you're presenting your side of the case?
I think for the most part, the personal responsibility theme is one that seems to appeal to most jurors, regardless of their political background. Personal responsibility seems to appeal to most. And sometimes uh, on the defense side, they will um, admit to liability for whatever reason they may have, but they'll just say they're arguing the nature and extent of damages, or meaning the injury, or they think that, especially for smaller cases, they don't think the impact could have caused those injuries.
Yeah,
So
so they can argue causation or the amount of the damages.
correct. And so we still use personal responsibility, because are you really taking responsibility for the accident when you admit that you caused the accident, but you're not admitting that you caused any harm, or you're not admitting that this person's hurt? It's kind of like, breaking somebody's window, and then you give them the bill. This is how much it's going to cost to fix the window, and you're like, well, no, I don't want. I'm not going to pay that. I'm going to find my own expert to try and find the cheapest way possible to fix that window. And so that's essentially what a lot of those cases amount to. Is
Okay, so personal responsibility, and that's interesting because I'm sure a lot of times defense attorneys are going to use that theme too and try to use that for their case. What have you seen on the defense side where you've thought afterwards, that was a pretty good theme? Anything come to mind?
I think that one of the things that defense does that helps them is when they are sympathetic to the plaintiff.
Hmm. Yep.
When in situations where they're rough and shrewd, I think that comes across poorly. And that gives us ammunition to excite the jurors and make them angry and want to give like a revenge verdict. Um, and so I believe there was a book called Atomic Verdicts that
Yeah,
talked about this,
right.
that when they're sympathetic to the plaintiff, that you know that can lessen the blow. for us. So that
That's a book written by a San Diego defense lawyer.
it is, yeah. But
Yeah,
plaintiffs have read it too to see what's
yeah,
gonna do.
absolutely. You got to read all those books.
Yeah,
But no, I think if the defense lawyers are trying to attack your client as somebody who is maybe trying to exaggerate or whatever, and all that, the danger is if the jury thinks they're getting beat up on and the other side's being unreasonable, the jury can get pissed off about that.
yeah, absolutely. I lost a case that way. I I had won a good number of trials. I think I can't I can't tell you right now the exact number, but I want to say it was 10 to 12 in a row. And so I was pretty confident myself. And I took a case, and because at that point I felt invincible. And I had gotten some comments from previous jurors that they liked when the defense attorney went after the plaintiff. They thought it was exciting, like the movies.
Right.
And so I thought, I'm going to try that in my next trial. And I was in front of a judge who um, seems to smirk whenever he sees that kind of stuff. And so I thought, yeah, this is the venue to do it. And I called the defendant by 776, my very first, exam. And I just I just went after. And it was the wrong thing to do. It wasn't me. It wasn't genuine. And it really turned off a lot of jurors. And I think that's why I lost, was because when I talked to them later on, they said it sounded like she wanted to tell the truth, but you weren't giving her the opportunity. And that just colored the rest of the trial.
Yeah. Well, that's a good point. I mean, when you get some success and you get some, number of cases in a row you win, you can get a little overconfident, cocky sometimes. And I remember as a young lawyer, I thought that the witness I was going to cross-examine in a trial was my mortal enemy, and I had to destroy them.
Yeah,
And I tended to be kind of like you're describing you were, but I realized it wasn't working so well. And you just kill them with kindness. If you're just very polite, very nice, you ask a question, they don't answer it. You go, well, I'm sorry, I must have asked a poor question. Let
right,
me ask it again so I can get an answer to my question. And you
right.
just keep at them, then the jury's kind of get pissed off at the witness for being a jerk to you, and you're being this nice person. And so I'm sure you learned that lesson, right?
Yeah, that was a tough lesson. Um, you just get these ideas. And I think it comes down to what I said before, is just being genuine and being yourself.
Yeah,
And, I'm not that person in real life. And why would I be that person in trial? That's just not me. And
good.
so,
That was a good lesson for you to learn. So now and I think when we were talking, you've tried a number of trials in the teens or something. Is that what it is these days?
um, I'm probably around 27 at this point.
Oh, well, that's good. You got a good number. So with that level of experience, which is good, um, what part of the jury trial, in your opinion and your experience, is the most important, and why do you feel that?
I think hands down would be voir dire.
Okay, and
Uh,
why?
I think that, um, and it stinks too if you get a bad panel, but
Yeah,
you
you
know,
can't control that.
yeah, that's like, oh my gosh. But yeah, I think voir dire is essential in finding out um, the type of person that is going to be most beneficial to your case, to your client. Um, and yes, you can get stuck with a bad panel, and you just do the best with what you have. But I think that the jurors that you have are going to make or break the case. Um, for me, the way I try cases, and the way I practice in general, is I'm always in pursuance of the truth. It's not I'm trying to win. It's I want the truth to come out, and the truth is worth something.
Hmm,
And I think that that's why my stress level has gone down a little bit, as opposed to how it was before, where I just thought about I just need to win. For me, it's more important that the truth comes out. And when the jurors see the truth, they're going to evaluate it the same way that I do. And you can tell a difference in the way somebody practices when they just want to win. I just got to win this case. I just got to win this case in trial or litigation. It's, you know, that just doesn't seem like the life for me. And it doesn't seem like justice. Um, I think that justice means we pursue the truth and then evaluate and distribute accordingly to the truth.
Yeah, well, that's good. I think that's a great insight. Um, one of the challenges of being a trial lawyer is you work your butt off and you know that case backwards and forwards. You know it probably better than anybody. Judge doesn't know it like know it. The client doesn't, the jury doesn't.
Right.
But at the end of the day, you don't get to decide it.
Right.
And you're always going to be stuck with somebody else will decide what happens. And so I agree with you. I think it's a mistake to say your value is winning at all costs, because that's problematic. And you start doing stuff that you shouldn't do because you're trying to win at all costs.
Right.
And if your North Star is the truth, that's good. And I've always trusted the juries and the jury system that they'll come up with the right answer, not perfectly, not 100%, but they'll do it. So my goal was always, as a trial lawyer, your job is to do your very best to try to present the trial and the case the very best you can for your client, to try to get a result that you think is a just result. And then
Right.
you got to live with that. I mean, if you've done your best and you don't get everything you want, that's just part of the process.
Yeah. And nobody can take that away from you.
Yeah.
I mean, regardless of, how much you try to, when you lose, you think back, I wonder if I would have done this. I wonder if I would have done that. That's going to happen. You can't help but get that out of your mind. At least I can. But, at least, you gave it your all. At least, you told the truth as much as you could tell it. And the chips fall where they fall, and you can't control that. But again, that's why I think that voir dire is so important, because you're leaving it to people that you're going to trust to do the right thing. And if you're getting warning signs during voir dire about how they think about things, regardless of how they view the evidence, or regardless of what evidence is, that's a problem. So
Well, in California, it's probably a different number in Texas, but in California, if you got a two-party case, you're going to get 6 peremptories per side. And so that's it. And you may have a panel of 40 people or however many they are. What do you do during the voir dire to try to explore the issues of whether jurors should be excused for cause? And what do you do to try to get that bad stuff out, get them talking, and then see if you can use for cause challenges that are unlimited as opposed to using up your peremptories?
yeah. Well, first, obviously, for personal injury cases, you want to eliminate people who are tort reform type individuals that believe that personal injury cases just shouldn't exist.
Right.
So you want to question for that. You also want to question for people that might place a ceiling on the value of the case.
Yep.
Now, no matter what, I'm not going to pay any more than this.
Yep.
Those are people that wouldn't be good for the jury, at least for a plaintiff side anyway. Defense side, those people are probably great.
Yeah, but let's say you get somebody saying that they have a ceiling on the case, and
Mhm.
you're talking to them. Now darn well when you're done with them, the judge is probably going to try to rehabilitate them with the old standard question of, well, will you listen to my instructions? Will you follow the law? Do you think you can do that? So what do you do to try to knock that rehabilitation out and get them to really say, yeah, this isn't the right case for me?
Yeah, that is so frustrating when they try and rehabilitate like that. Because they do it in such a leading way
Oh
where,
yeah.
where they say yes or no, and then if you're recording the voir dire and the court reporter is doing it, then they have it on record. That it's just so frustrating. But anyway, I just stick with, okay, But should the evidence show that the value of the case is this much, hypothetically, let's just say it's worth millions of dollars. Would you be able to award that? And you say, no. I mean, I think that's up far too much. I think there's runaway jurors, and people are just taking advantage of the system. And I think you can argue that this particular juror will not follow the law. They won't follow the evidence. And
Well, I think when you get that answer, you've gotten that admission.
yeah,
They're not going to follow the law.
right.
And, if the judge tries to rehabilitate him, you could maybe come back and say, well, Judge, yeah, you asked him a question, but he already told us he won't follow the law.
Right. Right. But I mean, sometimes you get stuck with that sometimes. They'll
Oh,
come
yeah.
and say like, well, no, I think I rehabilitate. I think he'll be fine. Like, what?
That happens an awful lot, as you know.
Yeah.
Well, in
And
terms
that's,
of, since voir dire is the most important, let's just explore that a little bit at this point. So when you're doing your voir dire of the jury, what's your strategy and how do you approach it? And what's your approach in cases? Do you make the decisions yourself on who you're going to keep or not? Do you use jury consultants? How do you make those selections and how do you go about talking to the potential jurors?
well, it depends on the value of the case, and if the case warrants a jury consultant, obviously we'll use one. The input can be invaluable. Most of the time, I can't think of a case that I haven't tried where I haven't focused it. So I use focus groups to identify the type of juror that would be beneficial to our case, and use the results of that focus group to question the panel. And that's usually what I do is I use that focus group as a guide to, okay, this is the type of person I'm looking for this case. And I try and get as many of those people on the jury as I can. And then from there, obviously you can't, not everybody, you're not going to find 12 people that fit
Right.
that up. That just isn't going to happen.
You're not going to get 12 of your favorites on there.
No. So you just eliminate the ones that for sure are just not going to go your way at all. And then, there's one strategy Jerry Spence used, at least they teach in TLC, is the show me yours strategy, where you kind of say, well, when I first heard about this case, I didn't believe this. And so, I was a little bit hesitant about the case. Does anybody else feel like they'd be hesitant when they heard this particular fact? The issue with that I found was some judges will call that preconditioning.
Yeah.
There's also another strategy where you ask the jurors, okay, let's say it's a lane change case. Who here can tell me the proper way to change lanes? Again, and I think, you have them tell you what a proper lane change looks like. Again, some judges will see that's preconditioning.
Yep.
So it just depends on the judge, but there's a lot of strategies that I try and use, and backups for those strategies should I get a sustained objection on the precondition.
Well, one of the things that you've probably gotten to use in maybe all of your trials or most of them that didn't exist 20 years ago is a mini opening. And what do you feel about that? And how do you use it in your cases?
I love mini openings when they're allowed. Most in my experience, that 50% of the judges allow for them. The other 50% don't want them. But it was upsetting. I tried a case in front of a judge and I argued for the mini opening, and they said mini openings aren't going to happen in this courtroom. And then the lawyer that tried a case right after me, he allowed the mini opening. It was the first time he ever allowed it. I was like, gosh, what argument did I not make to allow the mini opening? So I think that judge allows them now. I think they're invaluable. They can be a great tool for identifying jurors that are going to agree with the other side and opposing those early on. And so that's kind of the tactic that I use use them for.
Great. Okay. Well, now in this day and age where we've gone through a pandemic recently and everybody was shut down for a couple of years, you've been trying some cases since then. Um, and what, in your experience in dealing with jurors since we've come out of the COVID pandemic and shutdown, do you think they're acting any differently since we've come out and come through COVID? And if so, in what ways?
Well, I think for the most part, people are always skeptical of personal injury cases, especially because of the type of people that, tend to end up on the jury. Most of the time, they don't want to be there in the first place. And that's one thing I would always encourage all lawyers. And I'm hoping that to start a campaign of encouraging people to get on juries and do jury service and don't make excuses, because we need good people on the jury, please. And
Well,
so,
they're skeptical about plaintiffs' cases because they come in, they know you want money.
yeah,
And
of
they don't
course.
know whether you've got something where it's a real injury or not, or whether you're trying to get a lot of money, like, get more money than you should, or get money they don't think you should be paid. So they're always start skeptically.
That's exactly right.
Yeah.
So, you've really got to, find out again, and word out, find out who those people are.
Yeah.
Um, and so, um, those types of jurors end up on you'll end up with, I think, at half of the panel will be those types of people. And
Yeah.
so you just got to prepare for that. As
So
far
they
as,
start skeptical, but are they different in any other ways after COVID, you think?
well, I think in other ways, one thing that everybody can relate to now, that they couldn't relate to before, is loss of enjoyment of life.
Yeah.
And so everybody now knows what it's like not to be able to go outside, not have their life restricted, not be able to do all the things that they like to do. And it's more relatable now that if your client isn't able to do those types of things, and it's not just going to be for a few months or a year, it's for the rest of their life.
Yeah.
That's a lot more relatable now to people than it ever was before. And so that's one thing that's better than it was before.
Well, when you mentioned a little while ago a case where you called the defendant first under 776, and in California we can call the defendant first and cross-examine them in the plaintiff's case in chief. And I've done that and all that, but have you ever found in doing a 776 that maybe the defense, after you're done with your cross, is telling a lot of their story? And do you like that happening in the beginning of your case?
I've tried it in a couple trials. I don't like it, because I feel like in the beginning of your case in chief, you haven't earned credibility yet.
Yep.
And so you want to take as much opportunity in the beginning to earn credibility. And on the plaintiff side, we get the advantage of primacy. On defense side, you get the advantage of recency.
Yep.
So you want to make sure with your first couple of witnesses, you're developing as much credibility as you can. And how can you do that if the case doesn't start off going your way?
Yeah.
It's
Well, I mean, your cross may be great,
yeah,
but the problem I saw over time with the 776 is now I got to sit there and listen to this guy tell his case right at the beginning of my case. So I agree. I came to the conclusion I really didn't want to use it that much.
yeah. I mean, especially if after you delivered an opening and you're saying the case is going to go this way, and then you start with the defendant 776, and it's kind of like the record scratch. Like what? What? I thought it was supposed to be going this way.
Well, I think you're right. And credibility is so important for not only the trial lawyer and your client and your witnesses and experts, but you know, you've given that opening statement, and it makes a lot of sense that if you're going to have credibility, you got to start off with strong, good witnesses to start your case.
Right.
So you can build that credibility, right?
Exactly. Yeah. I think that the first couple witnesses are pretty
Yeah.
essential.
Yeah. They are awfully important. Now, in terms of when you're doing your, let's say, we've talked about a lot of things, so let's go over to your direct and cross of witnesses. I mean, I think sometimes people get so focused on the cross, which is very important, but they may miss that there can be important things in direct exam. So how do you help your client and help them do the best they can do and tell them their story on the direct exam when they're on the stand?
Yeah. I think you want to bring the case to life, not only for whoever's testifying, but for the jurors as well. And you do that using a variety of methods. I don't question from the podium. I try and I get permission to move out the well and try and bring it to life as much as possible. Bring the witness to whether it be some sort of drawing board or some sort of exhibit that they can demonstrate. I mean,
Yeah,
just making things as visual and touchable as possible for everybody, uh, just to keep for a lot of reasons. But I think it makes trial in general more enjoyable for everyone when you do it that way. And if you're just sitting there and you're questioning, reading off your questions off a notepad and from the podium, how you're not going to be able to grab the jury the way you want. It's I view trial as kind of like a little performance, and um, I think that's what makes it enjoyable for me, is
yeah.
making a performance out of it and entertaining the jurors and keeping them engaged and making it easier for my people, my witnesses to testify.
Well, and whether you're doing a direct exam of your client or you're doing a cross exam of another witness, I always used an outline, and I wasn't trying to write everything out because you got to listen to the witness. And
Exactly
whether
right.
it's your client on direct or somebody on cross, you got to listen, be in the moment, and follow where they're going that maybe wasn't in your outline, right?
Right. That's exactly right. And I'll have a kind of an outline of where I want to get back to, like questions I don't want to miss this area, or I don't want to miss this point.
Yeah,
Um, but and then there's sometimes you just got to know when to shut up because let's just say everything just went great and you think you want to go back and ask one more question, you might lose the magic of that examination. So, but I definitely agree with you. You want to listen to the witness.
yeah.
And,
But yeah, you're better off to ask one less question than one more question.
yeah, yeah. Last thing you want to do is that you just had a magical, back and forth, and then all right, well, I want to get back to this point, and then the rest of it you get creamed on. You just
Yeah,
ruined it.
yeah. Or the famous last words that no lawyer can ever live up to is, well, Your Honor, I only have one more question.
Yeah, yeah.
You really want to try to follow it up. So now in your final argument, and you're now going to wrap it all up and be talking to this jury and trying to bring to light how they should think about and try to put a value on the injuries your client has suffered. I mean, one of the challenges for jurors is there's no formula, and they're not really told there's any particular way they're supposed to use their experience and all that. But what do you find to be helpful in trying to give the jury some things to think about of, hey, these will help you think about how to put a value on what my client has suffered or lost or will be going through for the rest of their life? What do you do?
um, I think the easiest one for jurors to understand is the per diem argument, and using a board to break down non-economic damages and economic damages. in a way that is digestible,
Mhm.
and then they can see, okay, well, that's why they got that number. 9 times out of 10, I think that's the best way. I've seen it work where they come up with other arguments. There's the man in the black suit. I think that recently, I think they got ruled that you can't use that anymore. But there's other arguments I've seen used where they just ask for the number without
Right.
any justification for it. And I think that seems a little tough to pull off.
Yeah.
Unless the case has been going very, very well and you've earned that credibility, I would stay away from it. And I think that the per diem argument seems to work the best.
Yeah. So that's kind of what your go-to thing.
Yeah, yeah. And there's things that you want to do prior to arguing the money. I mean, I think David Ball says it correctly when he says that liability is defense turf and damages is the plaintiff's turf. I think that's
Yep.
right.
Yep.
But and there's this book called Persuasion, and it talks about using and it's a sales technique where, and you see it in commercials all the time, that this product used to be $100, but for a limited time only, you can get it for $39.99. So you show them the big number of first, but you're not asking for that for these reasons, and this is the smaller number and more reasonable number, and this is how we're justifying it. There's just a lot of little techniques that obviously I can't talk about because there might be some attorneys that go up against me in trial that are listening to this. So you gotta be careful.
Well, everybody who's a guest has different degrees of willingness to talk about some of those things.
I still have a lot of work to do and career left, so I gotta be careful.
That's all right. That's all right. Well, listen, David, this has been a wonderful conversation. I think it's been a very helpful and a conversation that listeners will find to be very helpful to them. So you are younger in your career, but you've been successful in getting enough trials to get into an organization like ABOTA. What kind of advice would you give to somebody who wants to be a trial lawyer and wants to get their experience so they can become an ABOTA lawyer or try cases so you get up to 10 or more? What have you learned in your years so far? Or what maybe is some great advice you got when you were younger? So what advice would you give to somebody who wants to try to become a good trial lawyer?
There's actually three things. The first thing is encourage all of your friends and family, everyone you encounter, to get on the jury, to do jury service, because we need jurors, and it's the only time, other than voting and jury service, the only times that we as regular people get to say how things go, and you want to take advantage of that. The second thing would be to make sure that you try cases. You can go to every seminar, class, all that, whatever, and watch people try cases. You can do all that and all of that. But there's a big difference between watching a boxing match, reading about boxing, and actually getting in the ring. And a lot of people think they're going to look like Mike Tyson, and they end up just swinging big circles instead because they just haven't gotten in there and done it. And so you've really got to make sure that you try cases and as many as you can, and just to hone that skill.
Yeah.
And the third one would be to be careful about what you appeal, be careful about what law you make, and this is on both sides. And the reason I say that is because the people on the other side that hire us would like nothing more than to get rid of us. A world without lawyers on either side. And so if we create law that makes it harder that take away decisions from jurors, we're pretty much just getting rid of our profession, which I think is a being a trial lawyer and the ability to present to a jury is something that I think is essential in society. And when we're getting appellate decisions and Supreme Court decisions that take away decisions from jurors, we're destroying the process, and we're only hurting ourselves. So we want to make sure that we're careful and thoughtful about what we appeal and the law that we want to make.
I think you would be careful, thoughtful, and strategic.
Absolutely.
I've seen too many cases keeping up with the new published opinions where something goes up and you look at the result and it doesn't make any sense that somebody would appeal it, and yet some bad law may be made.
Yeah. And this isn't just on the plaintiff side, it's on the defense side as
Oh, it's
well.
on both sides.
It's
Yeah.
on both sides. And look, I mean, we need each other. So don't create bad law that's going to eliminate both of us. We want to create law that's going to help us get things to a jury so we can decide how things go as a community, as opposed to just creating bad law that's just eliminating everybody.
Well, those are 3 good tips for people, and I appreciate that great advice. So, David, it's been a pleasure. Thanks for talking with me today on Trial Alchemy, and thanks for sharing what you've learned. And keep doing your good work for your clients and for our community, okay?
Thank you, Mondi, for having me here. I really appreciate it. It was an honor to be asked, because I just thought, like, wow, what does he want to interview me for? But I hope some people find this information helpful.
Oh, I know they will. So thanks again.
All right. Bye. Thank you.